The mere mention of three little letters, IRS, is enough to raise the blood pressure of most Americans. The IRS's reputation for being arbitrary, unfair, and ruthless makes even honest Americans shudder at the thought of a phone call or letter from this dreaded agency. Almost as daunting as the IRS itself is the tax code which it administers. The sheer volume and complexity of the tax code makes the law virtually impossible to fully understand, yet millions of Americans fill out the complicated forms and surrender a large percentage of their income to the IRS every year. Averaged out, the federal income tax takes several $1,000s a year from each man, woman, and child in the country. Were the income tax to disappear today, it would lift an almost incalculable burden from the workers and businesses of America. For most, though, freedom from the IRS is little more than something to daydream about. Recently, however, more and more Americans are claiming that even though they receive income, they do not owe the tax. While such a claim is obviously contrary to popular opinion, those making the claim insist that it is based on what the government's own law books say.
The problem with most discussions about the income tax is that people always start out assuming they know the conclusion being that everyone owes an income tax, and anything other than that conclusion is preposterous. The truth of the matter is that we have to start with the truth, and the truth is the written law.
Most who send money to the IRS have not personally studied the law, but do it because conventional wisdom says they should. Could such a universally accepted belief be contrary to what the law itself says?
Can you imagine a more skeptical person than me? Having been, and still today, a certified public accountant who was hired by the IRS in 1993 and served with distinction and had every intention of serving a full 20-year career with the agency, to have learned that contrary to everything that I had held dear and believed in the past, the agency was in fact knowingly deceiving the American public and was misapplying the tax laws.
While there have been tax protesters as long as there have been taxes, those involved with this issue, often called the 861 evidence, are not protesting the law at all, nor are they advocating that the law be changed or repealed. Instead, they are saying that the law as written shows that while income from certain international trade is taxable, the income of the average American is not.
Of course, the conclusion sounds unbelievable, but this is what the law actually says.
It's not a question of whether or not someone agrees with the income tax laws. It's a question of what the law is. This is not a tax protester issue. This is the truth. What is the truth? The truth is what the written law says it is.
Fear of the IRS, however, is enough to dissuade some people from even looking into the issue.
So many people are just simply scared to death of the IRS. They refuse to even listen or even read anything about the codes. It's amazing.
Nonetheless, the issue has been gaining thousands of supporters from all walks of life. Businessmen, doctors, engineers, ministers, musicians, even law enforcement and military personnel, as well as a growing number of CPAs and attorneys. Hardly people who fit the stereotype of an anti-government tax protester.
I've written legislation on some of the most complex issues in the history of mankind. I felt that with that experience and a little bit of hard work that I would be able to get in and find very quickly where in the tax laws my obligations lie. However, after spending countless hours going through the tax laws, I've been unable to find support for the government's position.
If evidence exists which can make such people doubt the age-old and almost universally accepted belief about the tax, might it also convince you?
I can't force people to accept the truth, but I can expose them to it. That's my desire at this point.
Ahead, we will take a look at the evidence in the law which is now threatening popular opinion, and we will examine changes to the law which some allege were done in an effort to cover up the truth about the tax. We will also see the surprising ways in which the government has responded, or refused to respond, to questions about this issue, and what actions they have taken against those who are publicizing the issue. Is this just a case of people trying to get out of paying their taxes, as the government suggests? Or is this a true David and Goliath story of concerned citizens fighting against a multi-trillion-dollar deception? You, the viewer, will have to make up your own mind. Based on the fact that the Constitution gives to Congress the power to impose taxes, and based on the wording of the 16th Amendment, most tax professionals believe that Congress has the power to tax any income it pleases. The law itself imposes a tax on the taxable income of every individual, with taxable income generally defined to mean gross income minus deductions, and gross income generally defined to mean all income from whatever source derived, including various types of income, such as compensation, business income, and interest. While these general definitions certainly give the impression that most income is subject to the tax, many now insist that these general definitions by themselves are misleading. The tax code specifically says that certain types of income are exempt, such as life insurance proceeds. It is generally believed among tax professionals that all income is taxable, except for such specifically exempted income. This view of the law is, however, now disputed by some, who point out that where the older income tax regulations talk about excluded income, they mention the income specifically exempted by the tax code, and then say that no other income should be excluded from gross income except income which is, under the Constitution, not taxable by the federal government. This implies that there are two categories of exempt income: income exempted by statute and income excluded because of the Constitution itself. Income not exempted by either would be taxable income. While all tax professionals know that some types of income are exempted by statute, most do not know that additional income is exempt due to the Constitution itself.
The idea that income could be excluded based on constitutional considerations is something that even lawyers don't often consider.
Most tax training courses and textbooks seem to rely almost exclusively on the general definitions, concluding that nearly all income is taxable.
I vividly recall the first day of my core class in individual income tax. We spent all of about 1 minute discussing the meaning of gross income. The instructor read to us the definition, all income from whatever source derived, and told us that that meant all income regardless of its source. That was it. We devoted the remainder of the course to the study of deductions.
The Supreme Court has said that even a very broadly worded statute must be interpreted in light of the limits imposed by the Constitution, and these regulations seem to show that there are constitutional limits on what would otherwise seem to be an all-encompassing tax. As an aside, these constitutional limits are mentioned in regulations written long after the passage of the 16th Amendment, showing that that amendment did not grant to Congress the power to tax all income. As the proponents of the 861 evidence point out, the Supreme Court agrees that the amendment did not extend Congress's taxing power to any new subjects. But knowing that there are constitutional limits is not of much value unless one can determine exactly what those limits are. Some believe the answer is found here. While explaining what income is subject to the tax, these older regulations said that income which U.S. citizens and companies receive from foreign commerce must be included in their gross income. They also mentioned the income of foreigners doing business in the U.S. and certain matters involving federal possessions, but do not mention the income of the average American. Does this mean that the listed items of income are taxable only if derived from these types of commerce, as the proponents of the 861 evidence suggest? Or does it mean that income from these activities, in addition to the income of the average American, is taxable? Is there some reason why the law might only tax income from international trade? Under the Constitution, the federal government has a few specific powers, and all other legal matters are to be handled by the states. While Congress does have jurisdiction over commerce with foreign nations, commerce happening within a single state is generally not a federal matter. That being the case, could the federal government tax the income received from such commerce? As 861 advocates point out, the Supreme Court once stated that because the Constitution gives Congress the general power to tax, as well as specific power over commerce with foreign nations, Congress can therefore undoubtedly tax income which Americans receive from foreign commerce. But what about income from business done in one of the 50 states, over which Congress does not have general jurisdiction. Is this list of international activities the answer to what is constitutionally taxable? The 861 advocates suggest that it is, and point to similar provisions in the current law books. The regulations say that the items listed in the general definition of gross income, such as compensation and interest, make up what are called classes of gross income, which in some cases include income which is exempt for federal income tax purposes. The reader is then directed to this section, which lists types of income which are not exempt. Again, the list includes certain foreign income of Americans, the U.S. income of foreigners, and rules about federal possessions and international and foreign sales corporations, but not the income of the average American. The average reader is left hanging, first being told that some income is exempt, and then being told that income from certain international trade is not exempt. While some might assume that the average American's income must also be taxable, even though not specifically mentioned, 861 advocates point out that the Supreme Court has ruled that when reading tax laws, one should not assume that they apply to matters not specifically pointed out. And it is true that the only types of commerce specifically pointed out in these regulations all relate to international or foreign trade.
I can find a lot of support for paying income tax on anything that I earn from investments overseas. I can find a lot of support for foreigners that are working here in the United States paying taxes on the income that they earn here. But I couldn't find anything that relates to me.
Even the instruction booklet for the 1040 form says that U.S. citizens must include income they receive from sources outside of the United States, but does not say they must include their domestic income. Is this too just an accidental omission? The 861 advocates also point to a principle of law which says that where the law specifically describes the things to which it applies, an irrefutable inference must be drawn that what the law does not mention was intended to be omitted. Therefore, because the types of income which the law specifically shows to be taxable are limited to international trade, proponents of the issue say that it is proper to conclude that the domestic income of most Americans is not taxable. If they are mistaken in this conclusion, there must be some other reason why these regulations say what they say. But as we will soon see, the government has been very reluctant to provide any alternative explanation of why the law says this. In addition to the issue of exempt income, there is another path through the law from which the 861 evidence derives its name, which the proponents of the issue say independently proves again the limited nature of the tax. They argue that one should use the rules found in Section 861 of the Internal Revenue Code and the related regulations to determine one's taxable domestic income, citing numerous sections of the IRS's own regulations which seem to say exactly that.
Sections 861B and 863A state in general terms how to determine taxable income of a taxpayer from sources within the United States after gross income from sources within the United States has been determined. The taxpayer's taxable income from sources within or without the United States will be determined under the rules of Section 1.861-8 through 1.861-14T for determining taxable income from sources within the United States.
Of note, very few tax professionals seem to be familiar with this part of the law.
Either CPAs, tax attorneys, or IRS agents are trained in this area. In my tenure as an IRS agent, I was not trained in this area at all.
Of the tax professionals willing to talk about it, almost all confess that they do not refer to the rules under Section 861 when determining someone's taxable domestic income. Most IRS employees also avoid these sections entirely, instead relying exclusively on the general definitions in the tax code, especially the section which generally defines gross income to mean all income from whatever source derived.
Their interpretation of that is that it's from any source derived, so that no matter where income comes from, the IRS would argue that Congress has the right to tax it. when in fact, if their interpretation were true, if in fact it didn't matter what source of, where the source of income came from, that all sources or any sources of income were taxable, there'd be no need to have a Section 861 that even talked about those rules.
Until recently, even the general definition of gross income was followed by a cross-reference telling the reader to refer to Section 861 regarding income from sources within the United States. Despite this, and other citations cited by proponents of the 861 evidence, many IRS employees still insist that most Americans should not be looking there.
Well, what I find perplexing is that the IRS says to use the regulations, but yet when we read the regulation and we apply exactly what it says, exactly as written, then we're said, no, we don't want you to use that regulation. Now, how can that be?
861 proponents suggest that on one hand, many tax professionals are reluctant to say that people should not look to the rules under 861 because of all the citations which repeatedly and unconditionally say the opposite. On the other hand, 861 proponents say that tax professionals also hesitate to agree that one should refer to the rules under 861 because of the extensive evidence, which we will examine next, indicating that only income from international commerce is shown by those sections to be taxable. Many are now alleging that the law was intentionally written to apply almost exclusively to income from international commerce to stay within the bounds of the Constitution, and that the general public was then intentionally misled about the proper limited scope of the tax, so that most Americans would falsely assume that their income is taxable as well.
We're not saying that there's anything wrong with the law as it is written. We're just saying that it's been misrepresented to the American public.
Many also believe that the wording and arrangement of the law has been changed over the years in a deliberate effort to conceal the very limited nature of the tax.
From the inception of the tax code, the scope of the law has not changed. The pathway to determine the law and how it actually applies to the individual has changed greatly. The government has taken great pains to convolute the statutes and the rules to make it harder for people to actually follow them and make the determination of their tax liability.
For example, the general definitions in the current regulations talk about some income being excluded by law, but they no longer specify that that means excluded by statute or excluded by fundamental law, meaning the Constitution. As a result, almost all tax professionals now assume that all income is taxable unless exempted by statute. A fairly obscure current regulation does, however, still mention the constitutional limits. As another example, the general definitions in the older regulations talked about income from international trade having to be included in one's gross income, while the current regulations also list several international matters as being non-exempt. That is no longer found in the general definitions, but is now thousands of pages away in a section which few tax professionals even know exists. Perhaps the most notable and most curious changes occurred in the statutes and regulations under what is now Section 861. At one time, this part of the law said that in the case of non-resident aliens and in the case of citizens who receive most of their income from federal possessions, the types of domestic income listed, after subtracting deductions, were to be included as taxable domestic income. Back then, no one could have mistaken this section to mean that the domestic income of all U.S. citizens is taxable. Later, however, the first phrase was removed from the statute, so that by itself the section then seemed to say that the types of domestic income listed were always taxable for anyone who receives them. The regulations, however, did not change, still showing that the general terms of the statute were about non-resident foreigners and Americans with possessions income. When the section became Section 861, Congress said that the correct application of this part of the law had not changed. However, there were several notable changes in the wording of the related regulations. The 861 advocates cite multiple regulations which state that Section 1.861-8 is to be used for determining one's taxable income from sources within the United States. The predecessor of that section said that the items which are considered domestic income are, after subtracting deductions, to be included as taxable domestic income in the case of non-resident aliens and foreign corporations doing business in the U.S. After 1954, the phrase mentioning foreigners was removed, making it appear that such domestic income after deductions was taxable for anyone who received it. Prior to 1954, that section also gave an example of how to determine taxable domestic income, which was plainly about a non-resident alien doing business in the U.S. While all the numbers in the example remain the same, after 1954 the phrase non-resident alien was replaced with a taxpayer, again giving the impression that it could apply to the domestic income of anyone. As another example, the older regulations dealing specifically with interest from U.S. investments stated quite clearly that such income is taxable when received by non-resident aliens, foreign corporations, and American businesses and individuals who received most of their income from federal possessions. After 1954, this section remained exactly the same except for the removal of the phrase saying who had to include such interest in their gross income. Had this part of the law expanded in scope in 1954, these changes would seem reasonable. However, Congress specifically said that the correct application of this part of the law had not significantly changed. With that in mind, the proponents of the 861 evidence allege that these changes show a concerted effort by the regulation-writing lawyers to deceive the reader about who could actually have taxable income from sources within the United States.
It appears that the intent is to deceive the public, to deceive the people that are reading those regulations.
The general terms of Section 861 itself now give the impression that the types of domestic income listed are, after deductions, taxable for everyone. However, the proponents of the 861 evidence say that the regulations still show that only income from certain international trade is taxable. In 1978, this section of regulations went from one page to an almost incomprehensible maze filling more than 30 pages, which includes many new legal terms such as classes of gross income, specific sources, operative sections, and statutory groupings. To summarize, it is the position of the 861 advocates that in order for someone's income to be taxable under the rules of Section 861, that income must come from one of the specific sources or activities which are listed here, which again, all relate to international or foreign commerce. Again, the regulations seem to intentionally leave the reader hanging. The reader is told to use certain sections to determine his taxable domestic income. Those sections show income to be taxable when derived from certain international or foreign commerce, but do not specifically say whether the domestic income of the average American is taxable or not. The 861 advocates again argue that if the tax code does not specifically point out that someone's income is taxable, it is a mistake to simply assume that it is.
This country was built upon the rule of law, which requires that any laws that impose affirmative obligations upon people must clearly and succinctly set forth what those obligations are, without equivocation, so that a lay person can understand what their obligations are. The tax laws as written are an intentionally confusing morass of verbiage that are designed to intimidate ordinary people, and in fact are designed to intimidate even the most educated and sophisticated reader.
In spite of the changes and the complexity, many tax professionals are still aware that these sections are all about international commerce. But being convinced that most Americans owe the tax professionals then assume that most Americans should not be referring to this part of the law. The proponents of the 861 evidence, on the other hand, insist that the regulations unambiguously and unconditionally require everyone to use the rules under Section 861 to determine their taxable domestic income, and suggest that the reason that these sections are all about international commerce, as the history of these sections prove, is because only income from international commerce is taxable. Over the past few years, thousands of letters about the 861 issue have been sent to federal officials asking the government to answer specific questions about the proper way to determine someone's taxable income. While the exact questions have varied slightly, two of the key questions have always been: who should use the rules under Section 861 to determine their taxable domestic income, And what types of income do those rules show to be taxable? Proponents of the 861 evidence argue that everyone should use those rules to determine their taxable domestic income, and further claim that those sections do not show the domestic income of the average American to be taxable, but instead only show income from certain international trade to be taxable. From this, they conclude that the domestic income of the average American is not taxable. Government officials, on the other hand, while insisting that almost all income is taxable, have been very reluctant to explain the specifics of their own position. When asked, for example, who should use the rules under Section 861 to determine their taxable domestic income, IRS lawyers have steadfastly refused to answer, while a few lower-level IRS employees have given conflicting answers. Some claim that those rules apply only to foreigners. Some claim that they are only for U.S. citizens with foreign tax credits. Others say they apply only to income from outside of the United States, while still others say that they apply only to those who have both domestic and foreign income. Some IRS employees even agree that everyone should use those sections to determine their taxable domestic income. In early 2001, over 100 congressional offices were sent 3 questions asking about how to determine taxable income. While a handful of those offices responded with IRS form letters which contained general assertions and often dire warnings, no direct answers to the questions were ever given. In 2003, over 100 people sent 4 questions about the issue to Barbara Felker, an IRS attorney specializing in Section 861 and its regulations. However, even she refused to answer the questions. Admittedly, it is more than a bit curious for a government lawyer who specializes in a particular part of the law to be unable or unwilling to explain what that part of the law means or say to whom it applies.
These questions were asked and they never got answered. And I started to watch that for a couple of years, and I realized that the failure by the federal representatives or tax professionals to answer this question really meant something.
This pattern of non-responsiveness has been occurring nationwide for a number of years.
I've encountered an incredible number of people who have just asked very simple questions of the IRS as to the way that they administer the federal income tax, dealing with questions about liability, sources of income, filing of returns. Very simple questions, and the IRS either refuses to answer the questions or they answer questions that were never asked.
While the government refuses to openly discuss the issue, it continues to spread as more and more Americans are beginning to study the law for themselves.
I'm not a CPA and I'm not a lawyer, but I can read, and when I look at the Code of Federal Regulations and the statutes, and they direct me to look at a particular place to determine my taxable income, I see no reason to do otherwise.
Again, it is impossible to determine what someone owes without first determining his taxable income. Yet when faced with specific questions crucial to making such a determination, the government has been surprisingly unresponsive.
The law says that some income is, under the Constitution, not taxable by the federal government. No one in the government seems to know what that refers to, so how do we know that it's not mine?
Interestingly, private sector tax professionals seem equally reluctant to discuss the issue.
A bunch of us sent a letter to over 600 local H&R Block sites. In the letter, we asked one simple question. Do you use these particular sections to determine the domestic taxable income of your clients? We got no substantive response from any of those 600 sites. I then called the corporate headquarters in Kansas City, and they told me that it was their policy not to answer such a question. To think that a company that makes millions of dollars determining people's taxable income can't answer a simple question about what sections of the law they use to do so, that seems bizarre.
If you'd like to ask your own tax preparer or any government official about this issue, specific questions can be found on the internet by going to www.861.info. That's www.861.info.
The IRS's own mission statement says that it is the IRS's job to help Americans understand their tax responsibilities. The man who now runs the IRS, Mark Everson, seems to agree.
The IRS must help people understand their tax obligations.
Days before making this statement, however, Mr. Everson's office received well over 1,000 letters from people across the country, all asking the same 6 questions about how to determine one's taxable income. No answers were given. At the same time, well over 1,000 letters asking the same questions were sent to John Snow, the Secretary of the Treasury. The result was the same: no answers.
I think there are no stupid questions. If you have a question in your mind as to what the law means, then you are entitled to an answer to that question. And frankly, if it's a question that's been asked over and over of the Internal Revenue Service, why is it so difficult for them to just answer that question? And once they've answered it, they can put it in writing and supply that to anybody that asks the same question again.
The government's most frequent response, rather than answering the questions, is to characterize the issue as frivolous.
And it's very telling that the IRS's response to this is, in many cases, and if not most cases, your questions are frivolous. If they're frivolous questions, why are so many people asking them? Just the fact that people want to know that they're calling on their government to explain it to them in good faith, reasonable questions, and the IRS will not answer these questions, that in and of itself throws doubt on the whole process. Why doesn't the government just answer the question?
Almost by definition, frivolous questions should be easy to answer. But for some reason, the IRS seems unable or unwilling to do so. Calling a position frivolous means not only that it is incorrect, but that the person who holds that position is either being dishonest or foolish.
All I'm doing is making a legitimate inquiry as to the application of a law to me. If the questions that I'm asking are too simple or ignorant, please be so kind as to educate me. If you can't, get someone else who can. Get someone within our $2.4 trillion government who can. Until then, don't insult me. Don't insult my intelligence. Don't get hostile when I speak about legitimate questions about the tax laws.
For years now, the government has been less than kind in how it characterizes the proponents of the issue. The former IRS Commissioner, Charles Rosati, referred to the issue as stupid and just plain nonsense. However, when Mr. Rosati received scores of letters asking the questions about how to properly determine one's taxable income, he also failed to provide any answers. Eileen O'Connor, the head of the tax division of the Department of Justice, once called the issue a patently frivolous scheme. In July of 2002, and again in June of 2003, she too received dozens of letters asking questions about the issue. She too did not respond.
The government cannot even allow this issue to come to honest discussion. They have to vilify those who would hold a position that's contrary to theirs and label them as scam artists, tax protesters, and the like, in order to criminalize their behavior, or at least give people the appearance of criminal behavior, to take the truth away from the issue.
Many of the people asking these questions admit that they do not know what the correct answers are. They just believe that asking the government for guidance seems like the honest, proper thing to do. Nonetheless, when they receive any response at all, it is usually a form letter in which the IRS refuses to answer the questions and accuses the ones asking the questions of being tax protesters.
The IRS has for many decades tried to cultivate an environment where they can label people in such a manner that they will not be listened to or their credibility will be destroyed. And I must tell you that in my experience, I've met a number of people called tax protesters who really aren't protesting a tax at all. What they're protesting is the way that the IRS administers the income tax, because many of these people have accumulated evidence to prove that the IRS is operating beyond the authority granted to it.
Even Mr. Bannister, previously a gun-toting special agent of the IRS, is now labeled a tax protester by the same agency he used to work for. The government has even taken steps to prohibit him from representing clients before the IRS, at least in part to stop him from raising the 861 evidence during IRS audits. Even some opponents of the 861 evidence have voiced the opinion that the government would be better served by simply providing specific, direct answers to the questions, rather than insulting, threatening, and trying to silence those who ask them. When nominated to be Assistant Secretary of the Treasury, Pamela Olson expressed a desire to restore the public's declining faith in the tax system, explaining how the belief that one is obligated to pay the tax does more for compliance than the fear of getting caught. This would seem to imply that the government could accomplish more with information and explanation than with threats and punishments. However, when Ms. Olson received almost 300 letters asking 6 questions about how to determine one's taxable income, she did not respond. A few months later, when her office received over 300 additional letters and dozens of phone calls about those same questions, she again remained silent. When the IRS responds to the issue at all, it is usually with one of several form letters, some of which briefly mention 861, but none of which specifically answer the questions. One of the form letters most often used by the IRS does not mention Section 861 at all, or taxable income, or gross income, or anything about the questions asked. Instead, it briefly describes how federal laws are enacted, and then opines that tax collection is necessary even if unpopular. The letter adds that some people advise others to violate the tax laws, and that the reader could be fined and/or prosecuted if he follows such advice. In short, thousands have asked how to properly comply with the law, and in response have received only threats of what might happen if they violate the law. The letter ends by saying that the IRS, quote, will not respond to future correspondence concerning these issues, end quote. Amazingly, the same letter says that the IRS seeks to administer the tax laws in a manner that warrants the highest degree of public confidence in the IRS's integrity, efficiency, and fairness. The IRS's own manual admits that such form letters carry no legal weight, and because the proponents of the 861 evidence base their position on the actual regulations, which are the IRS's official interpretation of the law, the proponents of the issue say that the IRS officially agrees with them, even if most individual IRS employees do not. Like other IRS form letters, this letter claims that the courts have consistently ruled against the arguments made by the one receiving the letter. Such a statement seems a bit strange when directed at those who are not arguing anything but were simply asking questions. Nonetheless, it is reasonable to examine what the courts have said about the issue. The majority of rulings cited by the IRS come from the tax court. While tax court rulings are not binding on the IRS or on any other court, and while no case goes before the tax court unless a citizen requests it, it is still worth seeing how the tax court has dealt with the issue. In short, the tax court has done just what the IRS has done, relying only on the general definitions of gross income and taxable income, asserting that this means that almost all income is taxable, and dismissing out of hand any argument based on Section 861 as being patently frivolous.
While that comes up a lot in the law, that something is frivolous, and a lot of appellate courts say that about arguments. Usually when they do that, they are willing to explain why it's frivolous. And once again, I never saw any explanation by any tax professional or any federal representative or any court, for that matter, that explained why the proposition that 861 and the related regulations said that certain income was not taxable was a frivolous proposition. And that caught my attention deeply, because that meant that no one, for some reason, no one was willing to look at it any deeper than just saying that can't be true.
Several judges have asserted that the income of the average American is taxable while refusing to address the substance of the 861 evidence.
I filed a federal refund lawsuit based heavily on the 861 evidence. I also filed official questions asking the Department of Justice to state the specifics of their own position, and in court the judge ordered them to answer the questions. They agreed to it at the time but never actually answered. Eventually the judge ruled against me without even mentioning anything about 861 or its regulations, and without the judge or the DOJ ever stating the specifics of their own position.
The court dismissed the suit as being frivolous, without ever saying who should refer to Section 861 and its regulations, and without saying what those sections show to be taxable. Perhaps even treating the issue as if it's worthy of discussion might pose enough of a threat to the status quo that no judge wants to be the one to delve into the issue.
The system is so broken that to get an honest ruling in the court in America today is almost impossible, to be honest with you.
Again, according to the IRS, while regulations are always binding, court rulings are not, unless they come from the Supreme Court, which has never addressed the 861 issue. The issue has been mentioned in numerous articles in the mainstream media, though the stories rarely delve into the substance of the issue or even accurately describe what the proponents of the issue believe. For the most part, the media has done little more than repeat the comments of government officials.
One New York Times article claimed that I think that taxes are voluntary. Not true. If you have taxable income, you're required to pay the tax. It also said that I think the tax laws are invalid, which is the exact opposite of what I actually say. They characterize us as tax cheaters or tax protesters. For 6 years now, I've gone out of my way to tell the government exactly what I'm doing and why. Is that the behavior of a tax cheater? And whether you agree with my conclusions about the law or not, characterizing me as a tax protester isn't just lazy reporting. It's an outright lie.
When dealing with cases involving 861, the IRS does not follow normal procedures. Frequently, the IRS simply disregards returns mentioning 861, refusing to even process them, often denying that the returns were ever received, despite certified mail receipts proving that they were. The IRS also routinely threatens a $500 fine for mentioning 861 on a return. Amazingly, on more than one occasion, the IRS has threatened to impose penalties on the same returns that it claims never to have received. Contrary to their own procedures, the IRS has often refused to grant administrative hearings to individuals who mention 861, instead skipping directly to issuing a notice of deficiency, telling people then that their only recourse is to petition the tax court, which has fined people thousands of dollars for just bringing up the issue. Amazingly, all of this occurs without the IRS or the tax court judges ever stating the specifics of their own position. On one occasion, an IRS spokesman, Terry Lemons, when asked about a group of citizens demonstrating outside a government press conference demanding answers to their questions about the tax laws, stated that enforcement actions are one way the IRS is answering such petitions and questions.
They can't address it, so they have to just automatically label it as frivolous. And then, as many of you know, they've come down by saying, we've answered it with our enforcement power. You don't answer a question with enforcement power, you answer the question with an answer. And when people don't follow the answer that is truly the law and it's shown to be the law, then you have enforcement power.
Those at the IRS have made it plain that stepping up enforcement efforts is their primary, if not their only method of responding to those who raise the 861 issue.
What you have is an enforcement authority, an enforcement mechanism that is designed to intimidate people into paying taxes because the laws don't say what people assume that they say. The presence of those types of forces in our government, armed with an absolute disdain for due process and constitutional protections with respect to property, are as antithetical to the laws upon which this country was formed as anything that I've ever seen.
One of the government's main enforcement tactics against those who raise this issue has been the use of injunctions. A provision of the tax code allows the government to seek court orders enjoining individuals from promoting abusive tax shelters, which is when someone sells a plan or arrangement, falsely telling people that participation in that plan entitles them to some tax benefit. Proponents of the 861 evidence allege that the government is intentionally misapplying this provision of law against people who are not selling any plan or arrangement and who are not claiming to be giving anyone a tax benefit, but who are instead simply showing people what the law already says about the taxability of income which the people are already receiving. Many see these injunctions as nothing more than a way for the government to circumvent the First Amendment in order to silence those who are drawing too much attention to the issue.
I think the First Amendment is one of the most important parts of the Constitution. If we can't speak our mind and ask questions, what are we free to do?
Through injunctions, court-imposed sanctions, and even attempts at disbarment, it is clear that the government seeks to strongly discourage tax professionals and attorneys from raising the issue at all in court or in administrative procedure.
Well, if you stand up to them, it isn't long before you find out that they don't care for you, and just as in my case, they retaliated against me, trying to put me out of business.
In light of the government's actions, it comes as no surprise that some professionals who agree with the 861 evidence choose not to be very vocal about it. One attorney, who has been in practice for over 30 years, made this statement.
After studying the income tax issues and the 861 evidence, I became absolutely horrified by the thought that we were now actually living in the Orwellian world of 1984. I've also discovered that any attempt by an attorney to disclose the truth about this issue will result in large monetary sanctions and potential loss of membership in the legal community.
For those tax professionals who do know, telling the truth can be a very scary thing, since the government is obviously trying to punish anyone who raises the issues or asks inconvenient questions.
Another attorney, wanting to remain anonymous, stated,
I have no doubt about the validity of using the 861 source rules to determine taxable domestic income. It is consistent with the constitutional limitations imposed on Congress's taxing power. But I have also seen firsthand the contortions the IRS and the tax court go through trying to avoid directly responding to the issue, and how the system severely sanctions any attorney who raises the 861 source rules issue.
Even if these individuals are incorrect in their conclusions, many find it disturbing to have Americans afraid to speak their minds due to government intimidation. And the government's efforts to quiet the issue have not stopped at insults, threats, or even injunctions. In May of 2003, armed federal agents raided the Pennsylvania home of Larkin Rose and the Texas home of Dr. Tom Clayton, two vocal advocates of the 861 evidence.
One attorney from the Department of Justice admitted, off the record of course, that the reason we had a dozen or so armed federal agents invading our home, rummaging through our things all day and night, taking boxes of personal property, was to retaliate against me for funding the theft by deception video.
Though neither Dr. Clayton nor Mr. Rose was arrested or charged with any crime, during those raids the IRS confiscated over 300 copies of a video entitled Theft by Deception.
The Supreme Court has specifically said that confiscating books or videos under the guise of a search warrant to stop their distribution, as the IRS did in this case, is illegal. When I called the Civil Rights Division of the DOJ to complain about this obvious violation of law, they told me that my complaint probably wouldn't be processed because it would be a conflict of interest, since the DOJ was, using his words, determined to stop the distribution of the video. They're busy violating our rights, so I guess it would be a conflict of interest to protect those rights.
Surprisingly, the confiscation of videos occurred without the government first taking any legal action to prohibit anyone from selling or distributing the video.
The video doesn't tell anyone to do anything. And the government isn't even alleging that there's anything illegal about it. They just don't like what it says. So they stole a few hundred copies in the hopes of keeping you from learning about the issue. It's nothing more than a modern-day book burning.
When asked, Donald Perlman, the IRS agent heading the raid, stated that the IRS would never return the videos, even at the conclusion of the investigation.
We were just doing what the law told us we should do. We were being completely open and honest about it, and we were speaking our minds, and they came barging in here yelling and screaming with guns and frightened our little girl. There's just no excuse for that.
They can't just address the issue rationally because their own law books agree with us. So instead they're doing armed invasions at people's homes, stealing videos they don't like, harassing our friends and acquaintances. Basically whatever Gestapo tactics they think might shut us up.
During the raids, the IRS also took dozens of theft by deception bumper stickers.
They want this silenced. They don't want argument. They don't want discussion. They want you to obey what they say the law is, not what you can determine for yourself the law is. Why is the government trying to silence this issue? Why are they trying to close off fair debate? Why don't they answer the questions? In a lot of cases, it's a matter of intimidation and censorship. If you don't do what we tell you you have to do, you'll go to jail. If you don't do what we tell you you have to do, we'll come with a warrant, come into your house, take your personal effects, take your personal records, so that you can't tell others the truth. Fortunately, we have the internet, which has gone a long way to spreading the truth on this issue.
Despite the actions of the government, the websites of Mr. Rose and Dr. Clayton are still up and their video is still being sold.